The lies and deceit in this Post Office Horizon scandal are more appalling and, quite frankly, shocking than perhaps anyone really realises. And to highlight that, I'm going to talk about a couple of points in one of the many judgments in this whole litigation. And to preempt that, I'm going to refer to a small snippet of my learned friend Alan Robertshaw's video, which I'll link in the description below for you to go and watch afterwards. But listen to this small snippet first.
In trials, you have what we call disclosure, where you have, each side can ask for documents from the other side. And the claimants asked for a report. They said, we would like a report about the Horizon system. And this poor old barrister had actually stood up there and said, no, this, we don't have this report. We don't have this report, so we can't get it. It's in the hands of third parties. And they would only hand it over if you were to make an order, ordering that. And the judge said, well, that's not really appropriate. I can't force third parties effectively who aren't involved in this litigation to hand over things. However, the barrister then found out that was untrue. The Post Office did have the report. They'd had it for over a year.
And for the rest of that, I'll invite you to watch the full video. There's a lot more than that in Al's video over there, so I'll link that below. But let's also go to one of the judgments itself to talk about this, because essentially what we're talking about is there were reports made by Fujitsu about the reliability of the software, the Horizon software, the potential for bugs and errors and things like that, and all of which was essential to the prosecution case against each of these sub-postmasters. So moving to that, and in reverse order, as many advocates do, starting with essentially the conclusion of one of these issues, the court said here that first, we reiterate that the Post Office deliberately chose not to comply with its obligations in circumstances in which its prosecutions of a sub-postmaster depended on the reliability of Horizon data. It did so against a background of asserting that sub-postmasters were liable to make good all losses and could lose their employment if they did not do so. So in other words, any errors the sub-postmasters were liable for, they had to reimburse that money regardless of liability and regardless of the accuracy of that information. It goes on, it did so despite the fact that the Post Office had itself selected the sub-postmasters as suitable persons to hold their positions of trust. In the High Court proceedings, one of the agreed facts was that the Post Office incurs expense and time costs in recruiting, including advertising for applicants and assessing and selecting applicants and training new sub-postmasters. Yet, if Horizon showed a shortfall, which a sub-postmaster did not accept as correct, the Post Office invariably accepted the position shown by Horizon, refused to countenance any possibility that the apparent shortfall made by the result of an error or a bug in the system, and was quick to assume dishonesty on the part of the sub-postmaster. As we've seen in internal documents relating to at least some cases, a sub-postmaster who attributed a shortfall to a system error was dismissed as jumping on the Horizon bandwagon. There were very serious failures by the Post Office to fulfill its obligations as a prosecutor. We are driven to the conclusion that throughout the period covered by these prosecutions, Post Office's approach to investigation and disclosure was influenced by what was in the interests of the Post Office rather than what the law required. That is quite a damning assessment of what happened at the hands of the Post Office, taking the software's result at its word and in turn prosecuting for fraud, theft, dishonesty, false accounting these sub-postmasters. Moving to part of the discussion of the issues where the Post Office made various concessions on certain grounds. The court said the concessions related to the failures of investigation and disclosure in all Horizon cases across a period of 12 to 13 years. And the court said that these concessions made by the Post Office were, in its view, quite rightly and properly made. It said in each of those cases, there was no independent evidence of an actual shortfall, and it was essential to the prosecution case that the Horizon data was reliable. So the prosecution was saying this software is reliable. The data it shows is reliable. Now, bearing in mind that this is any barrister that turns up was acting on instructions that were provided, the post office being the prosecutor in these cases, most of them anyway. The court said we accept and adopt Mr. Justice Fraser's findings, and throughout the relevant period there were significant problems with Horizon, which gave rise to a material risk that an apparent shortfall in the branch account did not, in fact, reflect missing cash or stock, but was caused by one of the bugs, errors or defects in Horizon. The post office knew that there were problems with Horizon. The post office knew that subpostmasters around the country had complained of inexplicable discrepancies in the accounts. The post office knew that different bugs, defects and errors had been detected well beyond anything which might be regarded as a period of initial teething problems. In short, the post office knew that there were very serious issues about the reliability of Horizon. If the post office needed further information, it could have obtained it from Fujitsu, the company that acquired the software. It was post office's clear duty to investigate all reasonable lines of inquiry, to consider disclosure, and to make disclosure to the applicants of anything which might reasonably be considered to undermine its case. You see, this goes to the rules of disclosure, which Al talks a little bit about in his video as well. These rules are very strict. The rules for disclosure in a prosecution is anything that would undermine the prosecution case or assist the defense, very broadly speaking. And yet there were failures in that regard. The court goes on, yet it does not appear that the post office adequately considered or made relevant disclosure of problems with or concerns about Horizon in any of its cases at any point during that period. On the contrary, it consistently asserted that Horizon was robust and reliable. Nor did it appear that any attempt was made to investigate the assertions of subpostmasters that there must have been a problem with Horizon. The consistent failure of the post office to be open and honest about the issues affecting Horizon can, in our view, only be explained by a strong reluctance to say or do anything which might lead to other subpostmasters knowing about the issues. Think about that phrase for a moment. The court came to the conclusion that the only explanation was that the post office was reluctant to do or say anything that would let other postmasters know about the issues with this software, because they too were likely experiencing these problems with false reports and readouts showing accounts owing money that in fact were not owing money. The court goes on, those concerned with prosecutions of subpostmasters clearly wished to be able to maintain the assertion that Horizon data was accurate and effectively steamrolled over any subpostmaster who sought to challenge its accuracy. Such a damning assessment of what happened. And coming back to the underlying principles and the reports and the data, we go again, as I say, in reverse order. Coming back here, there was a contractual obligation for subpostmasters to reimburse losses, as it says from paragraph 14 of this judgment here. The post office had a contractual right to seek recovery from subpostmasters for losses relating to branch accounts. The precise terms and legal effect of the relevant contractual provisions were considered at trial by Mr. Justice Fraser in the common issues judgment. We'll come to that in another video. For our present purposes, it suffices to say that the approach adopted in practice by the post office was that if Horizon showed a shortfall, however inexplicable to the subpostmaster was required to make it good at the end of the trading period. Some of the appellants did so using their own funds or borrowing or to make good a loss, which they did not, in fact, accept responsibility. Many people spending tens of thousands of pounds, some of whom were bankrupted, and obviously many went to prison for this, all while it was completely and utterly wrong. The court goes on, others resorted to offences of false accounting in order to cover up a shortfall for which they did not accept responsibility and which they were unable to make good. Fujitsu, this is where the data itself comes in. Fujitsu held audit data, which the court refers to as the ARQ data, which contained a complete and accurate record of all keystrokes made by a subpostmaster or assistant when using Horizon. It was therefore possible to refer the audit data to every transaction recorded in Horizon. Let's pause for thought there. Fujitsu, the software company, had access to every single keystroke. So breaking this down into simple terms, when what they were accused of doing was somebody would come in and spend money at the post office. They were accused of taking that money and not passing it on to the post office. So there was a shortfall. However, the software would retain every keystroke as a data audit log that was recorded by this software. The court goes on. It eventually emerged in the High Court litigation that Fujitsu had the ability to amend Horizon data in relation to a branch without the knowledge of the subpostmaster concerned. Fujitsu recorded bugs, errors, and defects in two types of documents. If a subpostmaster phoned the helpline, it was referred to the section of Fujitsu which investigated such matters. A document known as peak would be created. The peaks would then feed into a higher-level document known as a key error log. The post office had a contractual right to obtain any of the information about Horizon, which was held by Fujitsu. Some of the appellants sought disclosure of this data. However, the judge in that case heard no evidence to suggest that the peaks or the key error logs had been disclosed by the post office in any civil litigation or any criminal prosecution before the High Court proceedings. This court is in the same position, it says. It must have been really frustrating for the judge in this point. In the prosecutions of these 42 appellants, so far as we're aware, there was no disclosure of any such document. Breaking that down into simple terms, there were documents, there were audit trails and error logs, keystroke logs, everything with which could have proved that the subpostmasters did not in fact take this or steal this money. And yet none of that was disclosed. And so for more detail and more discussion, to not trample over his video, I will link Al's video in the description below. Go and watch that. It's an interesting watch as well. This video can be watched in conjunction with that. So if you go watch that and then you want to put that into the context of this one, come back and watch this one again. But as I say, there is so much more being uncovered in this case. It is frankly appalling, which is why it's been called the miscarriage of justice of the century. So with that, please do subscribe to get further updates on this, more thoughts that we have, more reviews of these judgments. And with that, I thank you for watching.